April4 Indian Express. First article is related to Imran Khan ducks no confidence vote in Pakistan, calls for early election. But the vote was not held as Suri dismissed it as unconstitutional and prorogued the National Assembly. Minutes later, Imran Khan blindsided the opposition once again by dissolving the National Assembly and asking people to prepare for another election. Okay. The continuation of the article is the Deputy Speaker dismissed the no confidence motion under Article 5 of the Constitution, which demands loyalty to the states in its first clause and obedience to the Constitution in its second clause. Okay. Next article that we are moving into is related to House panel calls in CAG official explain audit report delays. You have to know more about Public Accounts Committee because it is in news. Okay. Next topic that we are moving into is related to blockchain system in Gadchiroli to weed out the fake caste certificate. Maharashtra government is in process implementing a system to authenticate the government issued caste certificate through blockchain system. The system is to be put in place. The Maoism affected Gadchiroli district will also instant 30-second verification that will rule out any duplication or forgery of caste certificate. It will also help protect the rights of tribal. Okay. The other words, once the information is stored in the blockchain, no one can able to erase the caste records. This is what the article is all about. Next article that we are moving into is related to OBC Kushwaha votes on mind BJP to mark Ashoka's birth anniversary. BJP is to set out to celebrate the 2327th birth anniversary of Emperor Ashoka, who is said to have ruled most part of Indian subcontinent between 268 BC and 232 BCE. Okay. Next article that we are moving into is related to Goodbye ASFA. It's only prudent to repeal this act now. Study its record to strengthen the foundation of Indian democracy. As far back as 1776, Adam Smith in The Wealth of Nations reflected on the harmful effects of law that often continue in force long after the end of circumstance that first gave rise to them, and once again made them reasonable. In that passage, however, Smith didn't consider laws that are not reasonable even in the circumstances in which they were made. ASFA allows civilian authorities to call on the armed forces to come to the assistance of civil power. Once a state or part of a state is declared disturbed under this law, the armed force can make preventive arrest, search premises without warrant, even shoot and kill the civilians. Legal action against those abusing these powers requires prior approval of the central government and a feature that functions as de facto immunity from prosecution. ASFA was adopted in 1958 during the early days of Naga uprising to apply to what was the state of Assam and Union Territory of Manipur. It is hard to believe that to contend with a small group of armed rebels in the remote infrastructure poor region, it was found necessary to have law modeled on a colonial ordinance devised to tackle the Quit India movement, the most serious challenge faced by British colonial rule since the rebellion of 1857, as then Viceroy of India saw it. The counter-insurgency campaigns against Nagas were counterproductive, suffering brought by the forced displacement during the village regrouping. For example, only broadened support for the rebels. For instance, in Assam in 1990s, death squads or secret killers, as they were called, carried out a way of extrajudicial killing. These could not have occurred without the cover provided by ASFA disturbed area destination. This is not the only time Apex Court has been critical of ASFA. It is often forgotten that when it pronounced ASFA constitutional in 1997, it also recommended some changes. Among them was the stipulation that disturbed area designation to be subjected to review every 6 months. In some part of northeastern India, ASFA is now routinely extended every 6 months. This is what the article is all about. Next article that we are moving into is related to reading his mind. Vladimir Putin sees the West through the ultra-nationalist lens and is convinced that they are looking to leverage the economic and military superiority to forestall Russia from regaining its place in international order. Preventive wars, he said, are like committing suicide for fear of death. its decision to abstain from UN resolution condemning Russia should give it negotiating heft in with Putin. Also, our PM is on friendly terms with him as a forthcoming chair of G20 in 2023. India can climb locus standi. President Vladimir Putin has failed to achieve any of this objective. This is an indubitable fact. He has not succeeded in overrunning Ukraine through blitzkrieg military operation, in changing Zelensky's regime, nor in securing imperial and Russian sphere of influence comparable to what 10th century Vladimir Putin of Kiev had created, and which territorial extended even beyond the boundaries of former Soviet Union. In fact, on the contrary, Russia forces have got bogged by the fierce resistance of Ukraine military, and Zelensky has emerged as an exemplar of soft power of moral rectitude and communication. Moreover, NATO countries have not fallen over themselves in disagreement over their response to the invasion, but instead have conjointly imposed the severest of economic sanctions, which according to the economics will knock between 10 to 20% of Russia's GDP. In the words of Raghuram Rajan, should be likened to weapon of mass destruction for the misery it will bring to the Russian public. This is what the article is all about. Next article that we are moving into is related to reforming death penalty. Examining issues is raised in a specific case. Supreme Court has suo motu opened a review of process by which court award death penalty. What is the procedure by which the judges get relevant information for sentencing process, and why has the top court felt it necessary to intervene? Supreme Court has repeatedly expressed concerns over the manner in which trial courts and high courts have carried out sentencing with very little information. The bench headed by Justice Lalit agreed to comprehensively examining the procedure in death penalty cases to ensure that judges who have to choose between the life imprisonment and death sentence have comprehensive sentencing information. What has caused the Supreme Court to examine the practice in death penalty sentencing? While the death penalty has been held to be constitutional, the manner in which it has been administered has triggered accusation of unfairness and arbitrariness. How are judges supposed to choose the life and death sentence? The Supreme Court upheld the constitutional validity of death penalty in Bachchan Singh's case. A framework was developed for future judges to follow when they had to choose between the life imprisonment and death penalty. At the heart of that framework was the recognition that legislature in Criminal Procedure Code had made it clear that life imprisonment would be default punishment, and judges would need to give special reasons if they wanted to impose death sentence. The Supreme Court said the judges must consider both aggravating and mitigating factors concerning the crime and accused when deciding if the penalty is to be imposed. What has happened to this framework in 4 decades since Bachchan's case? Law Commission of India's 262nd report, one of the main concerns has been crime-centered approach to sentencing. A study by Project 39A looking at 15 years of death penalty sentencing in trial courts has shown that Bachchan phrasing framework has broken down, with the judges attributing to its multiple inconsistent meanings. What is the reason for this? Bachchan did develop a framework. It was framework that depend on the relevant information brought before the court. This was resulted in a situation where there is barely any meaningful information about the accused that enters the sentencing process. It is an empirical reality that vast majority of death row prisoners are economically vulnerable and very often receive poor legal representation. What is the mitigation and what are mitigating factors? A criminal trial was 2 stages: guilt stage and sentencing stage. The sentencing happens after the accused has been found guilty of the crime, and this is the stage where the punishment is determined. It is a fundamental tenet of criminal law that sentencing must be individualized. That is, the process of determining punishment, the judge must take into account individual circumstance of the accused. The complex interplay of various factors concerning our lives, and the emphasis that such interplay is different for each individual. who can collect all this information? The judgment in Santa Singh and Mohad Manan have recognized the interdisciplinary nature of such an exercise, that it requires professional other than lawyer to collect such information. Is this practical in India's justice system? There must be a high degree of fairness in the system that is interested in subjecting individuals to the experience of death row, ultimately taking lives through an instrumentality of the law. This is what the article is all about. Next, let us see in part 2 of the video. Thank you. If you like the video, please do share, like, comment and subscribe. Thank you.